All right, let's begin with the motion to dismiss. Who's arguing that one?
I am.
Ms. Lazaro, why don't we talk about that for a second?
Okay.
Where would you like me to go on that?
Well, I prepared an argument.
Go ahead.
I'm happy to address questions, or if you want to stop me midpoint and ask questions, however the court wants to proceed. But
Perhaps I can begin with a threshold question, if you don't mind.
yeah.
In order to grant the motion, I have to make a finding that some kind of conduct by the state's counsel rose to the level of a denial of due process or the denial of a right to a fair trial, right?
Correct.
A lot of that conduct you cite in your motion has to do with letters and filings made after a search of Ms. Richins' cell and statements or allegations regarding witness tampering or the danger thereof. Well, what if they just amended the information and brought charges for witness tampering based upon the same searches and the same evidence? And I use evidence loosely. I'm not suggesting that anything's admissible or wouldn't be subject to a motion to suppress. We'd be right where we are right now, but I don't think that would be misconduct.
I don't think so either, and here's why. If they had formally charged her, she would be given due process rights as it relates to the alleged witness tampering, right? We would be able to cross-examine people, she would get a trial, we'd be able to present witnesses, we'd have arguments whether or not evidence was going to be admissible or inadmissible. The problem with the way the state has characterized this in their briefing is the fact that they have definitively said she's guilty of it without being afforded any of those. And I think being charged with something is different than the state saying she witness tampered. This isn't the first time she witness tampered. This is further evidence of witness tampering, all of those things. And then they go on to say, you know, not only did she witness tamper, but because she witness tampered because she's guilty of murder. Like her witness tampering is a consciousness of guilt. And I can pull it out of the briefing. We prepared it in slides, but that's the problem, and that's the violations of rules 3.4, 3.6, and the ABA standards, is you can allege some through a filing or through a criminal complaint, right? She's here today because the state's alleged that she committed a number of crimes.
Sure.
Right? And she's going to get a preliminary hearing, and we're going to go through this entire process before we get to say she's guilty or not guilty. And the problem with the state's characterization over and over and over again, and in fact it got progressively worse or progressively more definitive in their statements that she is guilty of witness tampering, and that's the narrative that the media has picked up. And I think that's the violation of the rule, not, you know, if they had charged her with it, you're right, we would still have to deal with it. And perhaps there would be some press surrounding it. But we would also then have the opportunity to refute that or go through due process rights. But by just saying she was guilty of it, and by saying she was guilty of it is bad. By saying she witness tampered as a consciousness of her guilt is worse. By saying she administered the fatal dose of fentanyl is worse.
So
And they're
pause
tying
there
all
for a
of
minute.
this together.
A lot of that water went under the bridge as of the detention hearing. That is their theory of the case, that there was a financial motive, there was poisoning, caused the death of
Right.
her spouse. I mean, that's the case. Then we have requests for things like don't let her talk to certain individuals because, and then once we get into the because, their justification for the request is, we're concerned that she's trying to alter their testimony at a future trial. Stated broadly, everything I just described is part and parcel of lots of criminal cases.
Right, except for the fact that they go further to say, they have a theory, right? It's in the probable cause statement. She came out in testimony at the detention hearing. You're right. That happens in every single criminal case, and we can cross-examine people and weigh the credibility of witnesses as we go through. Okay? The problem is in their briefing, they dispel or they characterize the defendant's alternative theory or perhaps a potential theory of the defense as a false narrative, that it's a lie, okay?
Sure.
Which completely diminishes the credibility of anything we say. And then they've gone on to say, and all of her witnesses are lying, and she's telling her witnesses to lie. So now we're in a position where anybody we put up there, you know, a jury pool is gonna say, well, I mean, she witness tampered, so obviously these people are lying. And the state's already said that anything she says is a false narrative because it doesn't fit their theory. That's a problem, and the rules specifically prohibit the state from commenting on the theory of the case, or on alternative theories of the case, or on the credibility of witnesses. And
Trying to determine where the line between permissible advocacy and impermissible communications that would
well,
irreparably damage the jury pool. I acknowledge that however long jury selection was going to be at the end of the detention hearing, it seems like it's 3 times longer now. I'm with you, I got it. But why can't we, through a combination of lengthy and careful jury selection and instructions to whatever jury gets selected, mitigate the harms that you're describing?
I'm going to answer this in 2 ways.
Sure.
Okay, the first one is, I want to address first, is the rules are clear about what they can and can't do. And the rules are clear about prosecutors in particular, what they can and can't do. And they have a heightened duty. And there's case law out there that specifically says they have this heightened duty because things that come from the government come with more indicia of credibility, right? If the government's saying she's a liar and the witnesses are liars and any theory she has of the case is a false narrative because it doesn't fit theirs, that's a violation of the rules, like period, I think. Or at least that's our position, is they have clearly violated the rules in doing that. And in going so far as to make statements about her guilt. There's been a violation of the rules. I think what you're getting to is a potential remedy, and I think the prejudicial effect is that this is everywhere. We pulled, I mean.
But it was everywhere long before
It
this.
was, but it was everywhere before the state started making these comments. It was going to be everywhere. I don't think, I mean, I'm not gonna sit here and say that all of, you know, this wouldn't have happened or there wouldn't have been news stories, sure. There would have been news stories about this case no matter what we did. And I think that's a given. The problem is now these news stories have adopted the state's interpretation of the letter. And the news stories have run with.
Accurate? I mean, I have assiduously tried to avoid news coverage of the case
Right.
just to make sure that my consideration of it wasn't polluted by any inaccuracies in the popular media. But even I've bumped into the cover of People magazine, which seems to indicate or have at one time been providing a counter narrative that seems to be provided by the defense side of the video. I mean,
I think there
why
is a
isn't this a case of both sides airing their competing narratives to the fullest extent they believe is permissible under the rules?
I think you can advocate, but I think it has to be within the rules. And when you go so far as to essentially say she's guilty of witness tampering, and because she witness tampered, she committed murder, and the Today Show pulls a snippet and puts it by her face that says she, you know, she told these people to lie about whatever it is, that's a problem. And I think that goes a step too far. Yes, we can all effectively advocate. We're going to do it through briefing throughout this case, I'm sure. But I think there's a line in what you can say, and I think the rules are very clear on it. And when the state starts making conclusory statements about her guilt, about the credibility of her witnesses, about her credibility, about my credibility, I don't think, and then the narrative becomes, and the comments that we've pulled are, she's guilty, she's, why are we even doing this? This is just a box to be checked. Like, these are local comments. And yeah, you're probably gonna get some of those, but the state has taken it a step too far. And the other thing I wanna address is there was an alternative method to this. And in the ABA comments, this goes to the second part of your question, 2 questions ago, regarding, if they think she witness tampered, can they bring a motion and ask the court for relief? The answer is yes, okay? I think we can agree on that. The problem is in the way they characterized it and the statements they made in their brief. The second problem is it should have been, our position is it should have been done differently. And the ABA comments speak directly to it, and it's 8-2 point, one second, I'm gonna get there. I can only remember so many numbers. Point 1, and what it says is, a lawyer participating in a criminal matter should not place statements or evidence into the court record or into a document that is deemed an open record under applicable law solely for the purpose of circumventing the standard. If the lawyer has reason to believe that the public release of the record or document would create a substantial probability of harm to the fairness of a trial or other overriding interest, the lawyer should consider seeking a sealing order pursuant to standard 8-5.2.
Pause there for a minute. In order for a violation of the rules to be material, it has to have caused irreparable prejudice such that due process is violated, she can't get a fair trial. So let's stay focused there. I'm just not sure we're at that point, given the amount of publicity that existed beforehand, what the comments probably said before all of this, the availability of other measures. Dismissal is the ultimate sanction. And correct me if I'm wrong, I don't think you cited a case in which the case was dismissed prior to trial for this kind of conduct rather than during trial. Am I right about that?
Or after.
Okay.
Correct. Candidly, I did not find a case that stated that. I
mean, can we just acknowledge
Yeah.
that during trial, the options are so limited. The jury's already in the
Right.
box. We
Right.
can't re-impanel.
Right.
Jeopardy's attached.
Right. I think that is a different scenario. I think some of the cases, though, that came back on appeal, right? Like, it didn't get dismissed during trial. The conduct occurred, prior to trial. And those cases came back on appeal, for a new trial.
Those were embezzlement kickback side deal,
Mhm.
right? Not pre-trial publicity cases.
Correct.
Am I right about that?
Correct.
Okay.
So I do think it's nuanced, or it's difficult in these cases. I think we can all acknowledge that. But there is a process in place to ensure we can do the best we can, to take care that we all do the best we can, not to violate any of her rights to a fair trial. And the state, in their assertions and the statements they have made, have not done that. And the prejudice is we can't undo that, okay? This letter is out there forever, right? Whether it's ultimately admissible at trial, doesn't matter at this
It
point.
matters a little bit, doesn't it? Because if it were to come
I mean, I'm
in
gonna
a
argue it
trial-
matters because I'll probably move to motion to suppress it, but.
Well, sure.
Right.
So, I mean, but, and I'm not expressing an opinion one way or the other
Right.
about any kind of motion in that regard. But imagine the letter came in at trial. Any pretrial prejudice is now mooted. It's in. The actual jurors have seen it and heard it.
The problem is the statements the state has made during the pretrial phase, right? The statements that they have interpreted, this letter's open to multiple interpretations,
Sure.
right? And yes, we can get to that through cross-examination and
If it comes in.
Or, yeah, at trial.
Right.
The problem is that there is local, national, global media where the state has interpreted the letter in the way they want and has put out to the world and all of our potential jurors that Kouri's lying, that her witnesses are lying, that her theory is false, that that's the problem. The problem is their statements and the way they've interpreted it, and the prejudice to her is, you can't undo that. I mean, sure, we can probably ask people, questions in voir dire, but I don't think that's sufficient given the egregiousness of the statements. If it had just been, the way in my opinion, the way it should have been done, or the state's, or the defense's assertion is they could have moved the court for a motion for a no contact order. They could have filed it under seal. They could have filed the letter under seal. We could have had this argument, or in a way that wasn't the state saying that she witness tampered. It wasn't the state saying that her witnesses lied. It wasn't the state saying she's guilty of murder. Those are the problems, and those aren't going to go away. Forever there's going to be this issue that the states said that, and they can't do that. And if the courts, and I granted, dismissal is the ultimate remedy, right? But there are alternatives. I don't think any voir dire is going to cure this issue, given the egregiousness of the statement.
So I looked at the defense's proposed alternative remedies. I'm not prejudging a motion to change venue, but you haven't provided a basis to change venue yet. The dynamics that we're talking about, as far as I can tell, exist statewide, nationwide. This case was covered by the BBC. I don't know that you will find a jurisdiction that is, certainly not the state of Utah, that is going to be materially different than Summit County in terms of its saturation with media coverage of this case.
Correct. I think there will be other grounds, and that motion will come. We're fairly early in the process of this, so I do anticipate moving for a change of venue. Based on I agree. Unless we're going to some tribal land in Ghana, we're probably not finding people where it hasn't touched. But I think there are other issues that we will bring to the court's attention. That we believe would support a change of venue. We don't need to get into that today, but I do anticipate that will be coming.
Then we have disqualification in the Summit County Attorney's Office, and I'm not sure why that follows. Here, at this point, aren't they the most sensitized to the issues and the permissible bounds of what they can and can't say, rather than somebody else?
Wait, say that again.
Well, they've been involved. They're going to be subject to whatever ruling I make. I don't understand why disqualification of that office based upon public comments, conduct they've taken in prosecuting case, making motions, rather than extrajudicial things like those things that exist in other cases that were discussed in the briefing of embezzlement, bribes, that kind of conduct. Here, if you're right that they violated some ethical rules, well, now they know, and I would remain confident they wouldn't do it again.
I don't think that cures the problem.
Tell me why, though, on a going-forward basis. What is it about the continued involvement of the Summit County Attorney's Office on a going-forward basis that would be prejudicial to Ms. Richins?
I think if the court takes no action against the Summit County Attorney's Office, they're sanctioning what they said. And I think that adds additional credence to their statements.
Okay.
And I think that's a problem. Further, they've been involved in the investigation. Allow me a little more. Thank you. So, when they began investigating this case, I was having communication with the Summit County Attorney's Office. So they've been involved since the very beginning of this investigation and throughout it. And so they are intimately intertwined in the entire investigation as it went forward. Further, then they've said that this is our theory, there's no other theory, and the defense theory's got to be a lie because it doesn't fit with our narrative of facts, right? The problem is, you know, there's an insinuation that perhaps they drove the investigation, and this is where it ended up. And if it's
Tell me what you mean by that.
well, they made the ultimate conclusion that she's guilty in their briefing.
Okay.
Okay. And they were involved with the sheriff's office throughout the entire investigation, and they're saying that, you know, any alternative theory, say we, you know, go out and investigate and have investigators working and come forth with additional things or alternative theories or whatever, they've already said that can't be true because it's a lie.
Okay.
And because they drove the investigation or they were so involved in the investigation, I don't, you know, maybe they can go look for any. I think the implications of...
That's a great closing argument regarding Ms. Richins getting railroaded, but I'm not sure that justifies by itself
I think
disqualifying the Suffolk County Attorney's Office.
I think in order to fix the narrative that the state has put out there needs to be drastic measures. And one of those could be, or should be, you messed up and you're off the case.
I understand that argument.
I mean, I think that is the only, the only way to correct the violations that we've alleged, is to say, you know, that they made mistakes, they violated the rules, and therefore they're not on the case. I think that puts us back a little bit to center, where now we can go forward and we can present theories and there's a message out there that says, look, they shouldn't have made those statements, they can't make those statements, and by disqualifying them, the office as a whole, I think it sends a message to potential jurors that that's incorrect. And that there's
Isn't
potential...
that problematic as well, though? Where we'd be sending a message, I mean, we'd have to exclude all the jurors that had any sense of that, whether we're going to draw any conclusions upon that. We need potential jurors that were agnostic about that, wouldn't we? Meaning they didn't have an opinion one way or the other regarding the motives or conduct of any of the participants.
Right, but there's still, I don't think without proper remedies from the court, it restores Kouri's right to a fair trial.
Okay.
I mean, at the end of the day, we can't, doing nothing essentially just adds credence to what they said, and she's in a place now where, you know, we can't call these witnesses, I mean, we're going to call witnesses, but, you know, we're on the presupposed motion or assumption that, you know, the world has taken that they're liars because that's what the state said. And they can't make those, you couldn't make those in a closing argument. They couldn't get up there and say those things for a reason, right? So you should be able to say it now.
Well, I mean, let's be more specific about that. If they wanted to get up and say that, for example, if Ms. Richins testified to X, Y, and Z, I think the state would be able to properly say, listen, compare X, Y, and Z to evidence A, B, and C, the inconsistency shows that X, Y, and Z is a false narrative. That is proper closing argument.
Right, but it'd be based on evidence,
Fair enough.
right?
Yeah.
And you could, that is, I mean, that's what you advocate in closing arguments. You can say, you know, we presented this, the jury gets to weigh the credibility of everybody's witnesses, including the defendant, and make their own determination. They've circumvented that entire process by saying it now. They predispositioned everybody to look at these people through a lens that they're lying, to look at Kouri through a lens that she's lying, to look at Kouri through a lens that she is trying to get people to lie for her, to look at counsel, frankly, through a lens that I'm doing improper, you know, I'm doing nefarious or criminal acts, is what they've alleged. So that's the problem. They have essentially hit every single part of the rule that you're not supposed to violate. And the comment to 3.6 lays out things that are materially prejudicial. So I think that answers that question where they're making these statements now. 3.6 in the comments specifically says these things are materially prejudicial. And those are the things that they've done here.
Okay. I understand your position. It won't be the last time you get to talk. Let me hear from the state. Was there anything else you wanted to put on the record in the first place?
No.
Okay.
We'll just,
Mr. Pleasant.
Good afternoon, Your Honor.
State's briefing was a little general in terms of we haven't done anything wrong, there's no prejudice, let's just move on. Address Ms. Lazaro's argument that the things that the state said in its briefing related to the walk the dog letter are not the types of things that the state would be allowed to say in closing argument.
Your Honor, they are the things the state would be allowed to say in closing argument. It is fair argument, fair advocacy based on facts in the record today. And that's an important point here is that consistent with First Amendment jurisprudence on public access, consistent with the court's rulings on public access, these are public debates. These are the debates where the state makes its case in a filing, and the defense has an opportunity to rebut that case in the filing. They've just rebutted it, not only in their prior filings, but right here, right now at this podium. And that is fair litigation. That is how cases are litigated in criminal courts throughout Utah every single day.
Would you acknowledge that during jury selection, we will need to identify jurors that have no knowledge of a whole long list of things, including the briefing and media coverage regarding the walk the dog letter and the manila envelope and any number of other things?
Yes, Your Honor. Undoubtedly, the court and the parties will select a fair and impartial jury. That will take longer than normal. That will take a jury pool larger than normal, an enlarged questionnaire, expansive voir dire. But there are people in Summit County who are not following this case, at least a dozen or so. And there are people, who we can see as fair and impartial. Summit County Court set a jury in the Gwyneth Paltrow matter that received tremendous publicity. The court was right to note that much of this publicity is both national and international. More so probably than some county. I can think of 2 pending cases before this court, one civil, another criminal, that are receiving as much local ink as this case. And the court will see some accounting juries in those cases as well. As it relates to the walk the dog letter, and kind of this instant discussion we're having, the Algiers case that I can remember was the state or the defense cites in its briefings, in dicta makes, I think, a pertinent note that the publicity at issue in the prosecutorial misconduct and retrial motion was kind of a drop in the bucket to the overall publicity that the case received over the arc of time. That's where we are here as well.
Okay. Anything else from the state on this motion? We have plenty of other ground to cover.
Your Honor, if your questions are answered, I will sit down.
All right, thank you.
Thank you, sir.
Ms. Lizar.
There are a couple of things I'd like to address. if
Please.
you would so indulge me. The first point I'd like to bring up, and we addressed it in our briefing, is the state in their response briefing to this doesn't address really prejudice, as the court just noted. They don't address it at all. That they're, I mean, essentially, what they say is it maybe doesn't matter, but this is out there and so be it. The next thing, I think it's important to look at the statements. The state is saying that they could say these things in trial. They could say these things, perhaps some of them, if they're supported by evidence in closing argument. What they can't say, and I think I'll just pull out a few of the ones that I think are particularly problematic, is, they first say that the court needs a no contact order to prevent the defendant from further engaging in witness tampering. Essentially implying that she's witness tampered before.
Right, but I come back to the hypothetical if they had just charged her.
But they haven't, that's the problem.
I know, but isn't that better for her?
Well, yeah, I don't want any more charges,
Right.
I agree with you.
But isn't it a proper exercise of prosecutorial discretion to say, that is a distraction to prove that lesser charge? We're going to focus on the top level charges that are in the information.
Absolutely, absolutely. And I don't,
So the only reason I raise that is to say, in that alternative universe that I am describing my hypothetical, the information, the preliminary hearing, all that stuff would be transmitting the message, she's a witness tamperer. That is not different than we have here. It might be worse.
it might be, but it might not be, and here's why. The state concedes in their brief that they didn't have evidence that she ever passed the letter or witness tampered, right?
Right.
So we would actually get to stand up here and say or cross-examine people to essentially prove that that wasn't true.
Well, that's probably
So,
not to
and
too
I don't
far in
want,
one
yeah, I
direction,
mean, I don't
but
think that
why I'm
matters.
disinclined to prevent her from talking to her mother and her brother.
Okay, but the issue is that they have just declared that she's guilty of it, right? Instead of...
Is there anybody in the world that thinks the state of Utah doesn't believe she's guilty of the crimes for which she's been charged?
Is there anybody in the state of Utah? Well, I hope so.
Well, I guess, no, not that they believe personally, but that, does anybody out there think the state is just doing this as theater? I mean, the state's position from the beginning is she's guilty.
Right.
I don't think they've been unclear about that.
No, but the problem is that they've used, the way they've drawn the inference between witness tampering and the ultimate decision that a jury is going to make in this case after it hears evidence is that because she witness tampered, it's a consciousness of guilt. You know, she induced people to lie because she's guilty, right?
Isn't that similar to some of the arguments that we heard and on which I relied during the detention hearing regarding the internet searches? Consciousness of guilt, trying to hide conduct. I guess what I'm saying is that why is making arguments regarding a particular piece of evidence, admissible or otherwise, showing consciousness of guilt, why isn't that a proper conduct rather than improper conduct, whether it gets media attention or not?
Because the rules specifically say that they can't comment on her guilt. The rules specifically say you can't comment on the credibility of her witnesses. The rules specifically, I mean, it's clear in the rules, it's very clear in the rules what you can't do, and that's what they've done here.
But you're not suggesting that the rules prohibit, as a matter of law, making an argument regarding consciousness of guilt in a pretrial finding?
I think when you tie it to the ultimate, I think it depends on the context, right? I think you could use this phrase, consciousness of guilt, in a number of different ways that doesn't say she's guilty of witness tampering, we're telling you she's guilty of witness tampering, and because she's guilty of witness tampering, she's doing it because she's guilty of murder. And that's what you can't say. You can't go that far. Yes, there are probably a number of ways you could argue that in different ways that may not violate the rules. But the way they've done it here violates the rules because they're specifically commenting on her guilt in this case. The other thing I'd like to address is the APA standards essentially say there's different ways to do it. Like you could have done it under seal. This wouldn't have been an issue. She spent a vast amount of money. Taxpayers have probably spent a vast amount of money and time on this issue where we're not working, you know, it's limiting our ability to work on other things. We're doing this. Ultimately, this rests on, or what's alleged, she violated jail procedure policy. As well, they make that determination, okay? The jail has internal remedies to deal with that. And the jail has decided that she recently violated one of those, and they have prohibited her from contacting her mother. So there were other ways to accomplish this goal without creating a media narrative with the state's position on her guilt and the credibility of her witnesses. And I think, I just want to turn the court to the Hensley case. We relied on it in our briefing.
Is that the Fifth Circuit case?
It's a Fifth Circuit case.
That was during trial though, right?
It was.
Okay.
And I get that sometimes it's different. It can be different during trial because you've impaneled a jury. Those are the people who are sitting in it, right? I think that is different.
By implication, no other available alternatives to mitigate potential prejudice.
Correct. But it's still, and maybe these don't get litigated. I don't know. I mean, I don't know the answer to that. Maybe, I don't know how many people, how many arguments are had. If this were a case without a lot of press, okay, if this were normal course, like my 60 other whatever cases I have, right, that are going through the courts, you know, sure, we litigate things on the record, but nobody's looking at the record, right? It's not getting broadcast out to potential jurors. And so when you look at those types of cases in a normal course, it may not be problematic. I mean, it may still be a violation, but the prejudice may not be as grave as it is in this case. Because, you know, nobody would see it, right? The jurors, you know, we have panel juries all the time that have never heard of my clients and have no clue about anything that happened, and you know, they go about the normal course of business. And so the only thing that's brought to their attention are the things that are said in trial. And so that's why I think we see most of the case law come from that, because that's how majority of the cases go. This case is different because this case has so much publicity. Greater care should be taken to ensure we're not tainting a jury pool, to ensure we're not saying the things in pretrial matters that we couldn't say at trial, because the effect is the same. We're potentially causing the same harm that would happen in those other cases to a jury when it's broadcast to the world, where we have, you know, have jurors that have likely heard of it. And I don't think that the extent that the state has gone to in this case can be remedied short of, I mean, obviously we're here asking for a dismissal, but alternatively, without grave sanctions against the state. And we suggest that they be removed and this start over or continue forward, that's what I should say, with a clean slate, in order to, you know, put some order back in and, you know, go back and ensure her fairness, her right to a fair trial. These premises aren't lip service. I mean, this is essentially the most important thing we can be arguing at this point, is whether or not we can ensure that she gets a fair trial. I think that ultimately is the most important thing in a criminal case. It's, you know, the lofty reason a lot of us started doing this in the beginning, because we were going to be a champion for the rules. But, and I don't mean to make light of that. I think that's true for most of us who do this. But it is the most important thing. And so it can't be just, well, as the state says, like, too bad it's out there, we're just going to keep going, it's fine. It's not fine. It's not fine because they violated the rules, and the result of that is worldwide prejudice and a world that thinks that her liars and her witnesses and her counsel, you know, are going to misrepresent things to them or lie to them. And that's a hard thing to remedy.
I understand your position.
Thank you.
Thank you. The issue before the court is defendant's motion to dismiss due to prosecutorial misconduct. The gravamen of defendant's motion is that due to conduct by the Summit County Attorney's Office, defendant has been denied due process and her right to a fair trial. Specifically, defendant asserts that statements made by the Summit County Attorney's Office in briefing related to the walk the dog letter, briefing related to the Summit County Attorney's Office request for further limitations on Ms. Richins' ability to speak with her family members, have included statements that violate Rules 3.4 and 3.8 of the model and Utah Rules of Professional Conduct. Those statements include things like, quote, defendant is engaging in witness tampering or needs to be prevented from further engaging in witness tampering. The motion for no contact was based on the defendant's witness tampering and the breach of jail security procedures. The walk the dog letter illustrates the defendant's consciousness of guilt. With respect to certain explanations made by the defense for certain actions, that no such link exists in the evidence, that defendant concocts a false narrative, that defendant's own handwriting, she attempts to induce her brother to testify falsely, that she is facilitating witness tampering and supporting a false factual narrative, that she is giving her mother instructions to induce her brother to testify falsely, that this may indeed not be the first time the defendant witness tampered, and that defendant is making a frantic, dishonest attempt to explain how fentanyl came to be involved in this case. When viewed in isolation, these comments raise concern that they would cause undue prejudice by tainting the view of potential jurors in Summit County, the state of Utah, nationally, internationally, regarding Ms. Richins, her credibility, the credibility of her counsel, and her ability to defend herself in a fair jury trial. But when read in context, and given how these comments are anchored to evidence in the record and motions made by the parties, these comments are within the bounds of professional conduct under Rules 3.4 and 3.8. These are examples of permissible advocacy on behalf of the state in support of its request for things like further limitations on Ms. Richins' ability to discuss, contact, correspond with certain family members, and also in response to arguments made by defense counsel related to other litigation topics. Moreover, before this issue arose relatively recently, this case had already received an inordinate amount of media attention, an amount so large that it is frankly not in the interest of justice. But the First Amendment works the way it works, and I can't prevent that. What the court can do and require counsel for the defense and the state to engage in is measures to mitigate any potential harm from publicity regarding the advocacy in this case on a going forward basis. And that would include careful, lengthy, and detailed voir dire jury selection. We will need to identify jurors that do not have any preconceived notions of the subject matter of this case or any of the people involved in it. Parties, counsel, witnesses, etc. That may be a lengthy task, but it was made lengthy long before this issue arose, given the pre-existing publicity regarding this case. Moreover, these arguments would have been appropriate and without objection, the court expects, had Ms. Richins actually been charged with witness tampering. In that situation, the court would be making determinations about whether or not there was probable cause for the charge and there was probable cause to bind her over for trial, and these very same arguments regarding potential consciousness of guilt and materiality of the letter would have been made and would have been wholly appropriate. Here, based upon the briefing currently before it, the court simply isn't persuaded that the conduct at the Summit County Attorney's Office violates Rules 3.4 or 3.8, or or has caused Ms. Richins a denial of due process or a denial of a right to a fair trial, the court is confident that it can preside over a sufficient or dire process to ensure that Ms. Richins does in fact receive a fair trial. For these reasons, the defendant's motion to dismiss due to prosecutorial misconduct is denied in full. All right. Any questions, Ms. Lazar? Mr. Blood?
No, Your Honor.
All right. Let's move on from there. Let's go to the no contact order. The motion for no contact order. Mr. Bloodworth, you probably had this since when we last discussed this, but I am disinclined to limit Ms. Richins' ability to speak to her mother and brother for several practical reasons. First, I've got to swim pretty hard upstream against the First Amendment to enter that kind of work. Second, there are several non-criminal case related issues that she probably needs to be talking to her mother and brother about, and those are implicated in many of the motions and issues that are being raised in the civil cases, the estate case and the wrongful death case. And so if I gag her in this criminal case, I'm prejudicing her in those cases. Moreover, the cat's out of the bag. You know exactly what she's saying to them. All her jail calls are recorded, you have the letter, you're asking for the narrative. I don't understand what the prejudice is here.
Your Honor, let me take a second crack at it, and we'll, in the course of this explanation, get to the prejudice. Your Honor, in a sense, the court has its hands on a dial, and if it turns the dial in one direction, it can amplify the protection against witness tampering in this case. If it turns the dial...
Assuming any has occurred, right?
I'm only going forward.
Okay, fair enough.
Going forward.
Yeah.
If the court were to rotate the dial in the other direction, it could more narrowly tailor the prior restraint. And they're correlated, right? So if you amplify the protection, you're going to have a much broader prior restraint. And so when the state first asked for the no contact order, a lot of water under the bridge since then. When the state first asked for the no contact order, it asked for a lot of protection against future witness tampering, which also meant that prior restraint wasn't very narrowly tailored. I think we're at a point now, having all learned a little bit over briefing and argument before today, including today. Based on where we stand now, the state would kind of adjust the dial, accept some risk to future witness tampering in order to more narrowly tailor the prior restraint. And I recommend, to accomplish all of that, to include the necessary communication you referenced with your question. I think a more reasonable and appropriate order reads something like this: that the defendant shall have no contact with her mother, Lisa, and her brother, Ronnie, regarding the criminal case outside the presence of counsel. That would allow any necessary contact to prepare her defense. That would allow necessary conduct with her mother and brother to prepare her defense, but it would place counsel there to ensure that it was just preparing her defense. Then the order would read, any or all contact outside the presence of counsel will be either through an in-person visit at the jail or through the jail's home wave applications, text. And I say this because there is a monitoring component involved. The state is having to monitor the defendant to ensure going forward there is no witness tampering. And the state thinks the restriction on in-person and texting allows monitoring kind of without gaps. When we get into monitoring hours of phone calls, there are gaps.
Status quo, right now, a defendant in the Summit County Jail is given notification when they make a phone call that it may be recorded, right?
Yes, Your Honor.
In-person meetings, are they notified that those may be recorded?
Yes, Your Honor. They are audio and visually recorded. The inmate and visitor are both notified.
And status quo, the inmate can't pass anything to a visitor, correct, outside of counsel? And we'll get into that in a different motion, but is that correct?
Yes, Your Honor, that's correct.
Okay. So why do we need to be so specific? It feels like the Summit County Jail is providing all the protections you need to figure out what's being said.
At a lot of time, I put an extension to state, which is part of housing somebody. I appreciate that.
And
at
prosecuting them, yeah.
and at risk that we're missing something.
All right. Okay, I understand your position. Thank you.
Thank you, sir.
You'll get the last word.
Yes, sir.
I'm sorry, Ms. Lazaro, is this one yours?
Yes.
Just level with me. Do you think there's any part of this motion that I should grant?
No.
Okay. All right, is there anything else you want to say about it?
I think it should be denied, and I think that, I'm just going to reiterate, the problem is that the entire thing is premised on their accusation of witness tampering, which they have failed to prove.
Well,
I mean,
perhaps we can acknowledge that there are several plausible readings of the walk the dog letter.
yeah, if the court wants to.
One of the several plausible ones would be consistent with the state's version.
Correct.
Okay,
And one would be the defense's
agreed.
version, and.
I guess what I'm saying is,
if the
why do
court
I have
wants
to
go
figure it
so-
out?
Well, you don't, and that's the problem, we shouldn't
Okay.
have to. Like, that's the whole problem with all of this, is they're alleging a crime without any sort of due process, or without any sort of evidence to support it. The fact that that letter.
There's some evidence, I mean, the letter exists.
A letter exists, yes, but there's no indication in the reading of that letter that that letter could be written in the lens of, these are the people who are going to testify. I want them to remember these things, right? And that wouldn't be witness tampering. She can completely do that. Also, that letter was never passed or showed, and the inferences made by the state is just because she held up one letter that she was going to do it with this one, and that's the problem. Like, they have not made a showing that even comes close to a probable cause finding for witness tampering. And, you know, I think there needs to be some acknowledgement, if the court's inclined to deny that there isn't a finding that happened as part of it.
I think it's probably more important for me to make no finding whatsoever on that, isn't there?
Okay.
Okay. I understand your position. Mr. Bloodworth, anything further, sir?
No, Your Honor, thank you.
All right. issue before the court is the state's motion for no contact order that seeks an order preventing defendant from having any contact with her mother or brother to prevent further tampering with testimony. The state has narrowed the relief it requests today at oral argument to say that defendant should have all in-person, or to request that defendant have all in-person meetings with her mother or brother with counsel present, and that other communications be monitored in specific ways through technology available at the jail. First, the defendant has a First Amendment right and to correspond with whom she pleases and to say what she likes, as long as she doesn't do anything that requires a prior restraint justified by a sufficiently strong interest that countervails her First Amendment rights. Here, there's no evidence that she's done any such thing that requires her to be prohibited from speaking to any specific human being. The Walk the Dog letters have several plausible readings. It does not include any threats whatsoever or any other kind of communication that would typically justify a prior restraint on free speech. Moreover, there's no evidence that it was ever handed to anyone. And the state hasn't. So to the extent they need to cross-examine a witness or impeach a witness with its contents at trial, they would be able to do so absent some other ruling by the court excluding the letter or suppressing the search that found it. Moreover, the status quo is that defendant's communications with everyone except her lawyer are monitored. They're recorded. And the court's in no position to make that job easier for the state. So the court is simply not presented with a sufficient basis to restrain Ms. Richins' First Amendment rights. The motion for no contact order is respectfully denied. Okay. Anything further there, Mr. Bloomer?
No.
Ms. Lazaro. Okay. All right. Ms. Lazaro, the motion to enforce order for contempt sanctions, have I sufficiently addressed that in reaching the conclusion on the motion for prosecutorial misconduct?
Yes.
Okay. The court is hereby denying the defendant's motion to enforce order and for contempt sanctions based on the same reasoning that justified the denial of the motion for dismissal based upon prosecutorial misconduct. Let's turn next to the state's motion to compel good cause disclosures. Ms. Lazaro, can I start with your team on this?
Sure.
Is it you?
Well, I guess until I need a lawyer, it is.
There's a 60-page document. I have no idea what's in it. You claim you assert it's privileged, correct?
I don't, there is a folder, or a manila envelope
Okay.
that Ms. Richins kept in her cell.
Right.
That contains a lot of pieces of paper.
Okay.
Okay. As far as whether a document, our assertion, yes, is that everything contained in that is privileged by way of, it was given to me, it wasn't given to anybody else, it wasn't published, it wasn't, nothing else was done with it. So yes, that's our assertion.
So the defense asserts this 60-page or 60-something page document is privileged. The state asserts it is not and is material to their case because, depending on which version of the explanation you focus on, it reflects a partial factual, partial fictional narrative Typically, what we do is in-camera review and then allow the parties to make arguments regarding the content of the document and then have a legal ruling about whether it is in fact privileged and subject to disclosure if it's not. You have access to the document, so you're in a good place to make those arguments. I can't ask the state to argue about this with one hand tied behind their back. So, do we give the review attorney access to the document with a strict order that the review attorney cannot share any of the substance of the document, certainly not the document itself, with anyone from the state, and then have a sealed proceeding by which your team represents defendant's interests on this issue, the review attorney represents the state's interests, and then I make a determination?
We could do that, or the court could do an in-camera review. We, as a team, kind of really discussed this kind of came up last minute, as far as putting it on today. And I guess I'll put this question to the court, part as to how you want to go forward on it. Part of our, I think, concern or things we want to address as it relates to privilege is how and where it was found. And if the court is just simply inquiring as to the contents of the packet itself.
Well, but would you acknowledge that just putting a document in an envelope labeled attorney-client privilege and handing it to your attorney and no one else, that's not sufficient? If you put a takeout menu in that envelope and hand it to your attorney, the takeout menu is not an attorney-client privilege communication.
That's correct, it wouldn't be, but this isn't a takeout menu. These are her handwritten notes.
I know, but I don't know what they say. So if they are in fact a fictional narrative where she's just writing a short story, I'm not sure they're privileged at all.
Well, I think.
But I'm also not sure they're materials either.
I was gonna say, I think it needs, before anything, whether it's reviewed by the court in camera or whether it's reviewed by Mr. Jordan, I think there needs to be a twofold analysis as to what and what not is privileged, and then what and what not may or may not be relevant before it's turned over to the state for review.
I agree. What I am reluctant to do is make that determination in a vacuum without the benefit of advocacy by the defense and the state. And so I agree with you, though. It's a two-part determination. And the privilege issue is a gate. If I determine that it's a privileged communication, it does not get produced, no matter how material it is.
Correct.
All right, let me ask the state about this. Mr. Bloodworth, you see where I'm headed here procedurally. Any objection?
No, Your Honor, that's what the state asked for.
It was unclear to me, though, whether you were asking for the review attorney to just make the call or have only the review attorney brief it, but what would need to be clear is the review attorney would have access to this, would be the state's agent, would represent the state's interest, but none of your team and none of your office, nobody else in the executive branch could have access to the document or disclosure of its contents
Correct,
until
Your
I
Honor.
made the ruling.
Your Honor, I'd back off a little bit of what you said and say the review attorney is not the state's agent, he's a neutral. He was selected by the defense counsel.
Not in my proposal. My proposal is the review attorney represents the state on this issue. Because Ms. Lazaro and her team are going to be making advocacy arguments on behalf of the defendant that I imagine go in the opposite direction.
Well, Your Honor, I imagine the state too would present advocacy on its behalf, at least to the threshold matter of privilege.
How? You won't know what's in the document. So you need a lawyer that has access to it, and it can't be a member of the litigation team.
No, Your Honor, to some degree the state does know what's in the document because the state has listened to jail calls where the defendant describes in great detail what's in the document. And that
Maybe, but we have no idea if that description is accurate or not. The document speaks for itself.
Correct, Your Honor, but how the review attorney interprets the document will depend on some measure in the defendant's characterization of it. So the state,
Fair enough, and so will the defense have to navigate those waters.
yeah, sure. The state envisioned and asked for a procedure with the review attorney or the court. We asked for it in the alternative, whereby both the state and defense can present legal argument based on whatever facts they know as to whether or not particular material inside the envelope is privileged. And then he can make a threshold determination on privilege. And then, once we're past that, there may be a material determination around
It's not the way this usually works. I mean, candidly, where you're describing hamstrings on both sides, I'm not even sure it would be reviewable if we did it that way. Why wouldn't we just have the state designate, I imagine it would be outside counsel, who for this specific task is walled off from the state's prosecution team? When I represented members of the media, this is how we did it. Right, like I can't share any of this information with the reporter, but I can argue why they should have access to it based upon the content of the document. Where do you see the error here?
Your Honor, the state's agreeable to pursuing it in the fashion the court described. I've seen it work both ways. I think the way you described is perhaps more common in civil litigation context than in criminal one.
Sure.
And I'm fine to proceed, the state is fine to proceed in either fashion. The state's, the thrust of the state's argument is the material needs to be reviewed by a neutral. The defense alone cannot make the privilege determination.
I don't disagree.
And whatever procedure the court prefers to accomplish that, the state agrees to.
Okay, I appreciate that. Have a seat. There's a lot of chatter over there, Ms. Lazardi.
Sorry.
You feel like we need to go in a different direction?
Just, I guess, 2 points I'd like to make. Given that the court is viewing the review attorney as an arm of the state, our preference would be that the contents be reviewed in camera for at least the initial.
Maybe I'm wrong about that. Forgive me. I mean, the existence of the review attorney,
Generally speaking.
their identity was new to me until I read the briefing on this issue, right? And so it doesn't have to be the review attorney, but what I am trying to avoid is, on the one hand, the court making this determination without the benefit of the adversarial process.
We're not asking for that. I agree with the court's proposition as to how to move forward, and that it first get reviewed for privilege, and then we address materiality of it. I don't think, when we're talking about the first step and the privilege, if we're arguing about whether or not certain things contained in there are privileged or aren't privileged, the state, it's the counsel here today, should not be able to make those arguments because it negates the whole point of privilege.
That's my point.
Okay.
And so that's why I think they, in my version of the procedure, need to have an outside lawyer whose sole role is to make those arguments on behalf of the state.
Right. And we have identified Mr. Jordan as
That
an agreed upon review attorney
Okay.
as it relates to that. So I guess I'm envisioning probably 2 separate processes. We'd have a hearing on, or at least briefing on privilege and then a briefing on materiality.
Yeah, maybe we can just do it all at once. I don't know.
Well, I guess, yes. Well,
If you're going to review
yes,
the documents,
that's
you're
fine.
briefing this.
That's fine. The other thing I just think is an important, like a side note, and this is probably going to come up in the briefing, the jail searched that packet multiple times and passed on everything in it. It was, and I'm just bringing that up as, and like I said, it'll probably come up in argument, but you know, they've already, you know, they have been through it. So,
I'm not sure what the significance of that is, but I don't know that I need to.
yeah, we don't need to
right
get
now.
in it today.
Okay. All right, so,
Do you have any other questions?
no, I have some practical questions for the state. And if you're not prepared to answer them right now, Mr. Bloodworth, I'll understand. I'm moving this issue in a direction maybe you didn't anticipate, but are you prepared to stipulate that the review attorney, Mr. Jordan, will be the state's attorney for the purposes of this walled-off review of the 60 whatever page document? Or do you want to designate a different lawyer and keep the review attorney separated for future tasks? Maybe you're not.
Your Honor, I want to consult with my team briefly on this, and part of the reason why is the review attorney is already engaged on other reviews.
Right. Okay.
And so my sense is we need a new attorney.
Maybe so.
That I don't want any of his other reviews to
Be affected.
be affected.
Okay. Why don't we're going for about 90 minutes. Why don't we take a 15-minute break?
Before we get there,
Yeah.
can I just make one more point?
Sure.
I think before we get to the point of whether or not they're privileged or not privileged, we need to address whether or not we should be compelled to turn it over to start with.
That would depend upon materiality, right? I think that's right.
I mean, I think the
Hypothetical.
state needs to make a showing as to why they think they get this packet, first
No,
of
no, no,
all,
I-
right?
Well, all right, so let's put aside any issues of whether the way the document came to the state's attention is appropriate, should be suppressed, excluded. Put that aside. I don't have any motion like that in front of me.
Okay,
The state knows about it. They know some things that Ms. Richins has said that they think refer to the content of the document. Don't know whether or not they're accurate, we'll find out. Whether the defendant has to turn it over under Rule 16 will depend upon whether it's material, right? Whether there's good cause for the disclosure. Hypothetically, if she's like, here is a timeline of how this went down, and just gives a list of admissions, and somehow it's not privileged, right, that's the kind of thing that would need to be handed over. If it's, here is a short story about Care Bears, I'm not sure it's the kind of thing that needs to be handed over. Do you see the law differently?
well, I guess in my mind, we need to go back a step. I mean, we're talking about whether or not things are privileged or not privileged, and then if they aren't privileged, whether they're material. Before we get to that, I think the state needs to provide a good cause showing as to why they think they get it. And I think it doesn't, before we ever get to any of those steps, like,
Well, I
why?
think they would say they have a sufficient threshold to trigger the privilege review based upon the portions of the recordings of Ms. Richins' jail calls in which she says this is part fictional, part factual. Am I summarizing that correctly, Mr. Bloodworth?
Yes, Your Honor.
And so there's a reasonable inference in the state's view that the parts that are factual are backward-looking statements about what happened. They're factual. We'll find out. But there's at least enough that the state has presented to trigger your need to assert the privilege, maybe move to suppress, I don't know, and then to trigger the related materiality review. You see it differently?
That's fine.
Take a recess.
Why don't we take
a recess?
Yeah. we can
Okay,
use that.
sounds good. Listen, there's a lot of people in here, so if you need to get up and move around, that's fine, but it's 15 minutes. So if you don't want to get locked out, consider staying put. We'll be back at 3:20. Thank you very much. See Rule 16C and tell me if you see it the same way.
Okay.
So, initially, the only thing the state has to show is the materiality of the information requested from the defense before the defense is required to either make the information available or assert a constitutional privilege, such as one against self-incrimination, an evidentiary privilege, such as the attorney-client privilege, or a counter-argument that you're wrong, it's not material. Why aren't we at that point where you're saying, for example, it's privileged, maybe additional privileges and arguments will be raised in the briefing that would occur behind seal, such as what they want would implicate Ms. Richins' right against self-incrimination or it's not material. That's what I'm trying to have play out through the adversarial process, and I don't know what's in the document.
Right, I think perhaps the state needs to make a good cause showing that they're entitled to it, I think, before we get to whether the materiality of it.
I think that's where we differ, and the reason I say so is, and I'm happy to be educated about this, but State v. Spry, 2001, UT App 75. We further hold that the good cause, quote unquote, under Rule 16C requires the prosecution to establish only the materiality of the information requested from the defense before the defense is required to make such information available to the prosecution. But also that things like the right to the privilege against self-incrimination is paramount and therefore overcomes that good cause consideration. The state in its motion is saying, we think there's good cause here because based upon our interpretation of the content of the jail calls, this is a factual, partially factual narrative. Therefore, it's material. I don't know if that's true.
If that's the court's position, they've only made that as it relates to the 60 pages, not the entire packet.
I agree.
So
Are we talking about the entire packet?
Well, it was unclear to me.
Mr. Nate says yes.
Yes, I was asked to turn over the entire packet.
Is that accurate, Mr. Bloodworth? I thought the briefing was I agreed to turn over the 60-page document, and then upon reflection, I can't do that
And
anymore.
then it was further requested that I give the packet to the review attorney. And the problem
Did I
with
just
that.
call Mr. Hayden Mr. Nate?
It's okay, you're up.
Yeah,
I apologize.
The problem with that is I can't, once I assert a privilege, I can't turn it over or I waive the privilege,
Understood.
and I can't turn over a part of it. So I guess what I need from the court today is an order telling me I need to turn over the 60 pages. If that's
No.
what the court's inclined to do.
No, I'm inclined to not do that.
Well,
So
am I,
let's
do I
let's
need to?
take a step
Okay.
back. I understood, Mr. Bloodworth, that we were talking about the document, not the folder.
Your Honor, there's letter number 2,
Is that the one she held up?
which is the one she held up,
Okay.
and then 60 or so pages of what she describes as the continuation of the walk the dog fictional manuscript.
Okay. Are those the two documents we're talking about?
Yes, Your Honor. We don't know what else is in there to make a good cause showing.
Well, that's the way it goes, though, when people are handing an attorney-client privilege or a marked folder their attorney.
Well, yes, Your Honor, but when removal of the material from the jail violates jail policy, that adds another wrinkle to it.
Let's stay focused on the two
Yeah.
documents. I don't have enough to speculate about what may have been in or not in that folder, and now I understand the significance of Ms. Lazaro telling me jail staff went through the folder several times. Now I understand where you were headed with that. Let's stay focused on just the two documents. The one page that was held up, which the vernacular for that is letter number 2.
The vernacular is letter number 2, Your Honor. It was multiple pages.
Okay. And then the 60-ish page document.
Correct.
Why shouldn't we handle those two documents in the way the court proposes?
I have no objection to that, provided that the court order me to give them to the review attorney. or
Right.
in court. I have no
Understood.
objection to those two documents.
Okay. Well, we're
so
going to need to
long
put
as-
an order in place first, identify who either the review attorney or the shielded representative of the state in this process is. And listen, I understand that normally the court would just review a document and make a determination about privilege. This case is very high stakes. It's an aggravated felony. It has enormous amounts of attention. I don't want to make this decision without the benefit of the adversarial process, so we're going to use belt and suspenders on this one. Have you determined, Mr. Bloodworth, who is going to represent the state in this process?
Your Honor, not by name.
Okay.
We can, but the state will select somebody at short order to serve as the state's advocate in this process.
I appreciate that. What I'm inclined to do is order counsel to meet and confer regarding the terms of an order that will control how this process unfolds. It states in black and white who is allowed to have access and not allowed to have access to the 60-page document and letter number 2, and then hopefully provide some deadlines for submitting the 2 documents to the state's shielded attorney and briefing deadlines for getting it before the court. Does that sound reasonable, Ms. Lismer?
Yes.
Mr. Bloodworth?
Yes, Your Honor.
That is the state's order. Can you meet and confer on that within 1 week?
I am, yes.
Or
It's
no?
like- Probably not, actually.
Okay.
I'm gone. I'm going to be out of town working the majority of next week, and I'm on vacation the following.
How much time would you like to get this sorted out?
Can we go to maybe the beginning of December?
By December 1, I need a proposed form of order or competing proposed form of order submitted to the court.
And just so I'm clear today, the court's ordering me to,
Not disclose anything yet.
okay, until you have this
Until
proposed
the
order. Okay.
rules of this review are set, the participants are identified, those that cannot participate are identified, and that order's in place.
Okay,
Then everybody will know what they can and can't do.
understood.
I think that's the appropriate way to handle this. Any objection, Mr. Glover?
No, Your Honor.
Okay. All right. That handles for today. The motion for good cause, motion to compel good cause disclosures. To be clear, I'm not expressing any opinion one way or the other about what's in this document, whether it's material beyond the facial prima facie showing of good cause, or whether any other privilege would apply to it. I just don't know what's in it, and I need better briefing regarding the circumstances under which it was created, who it was provided to, things like that. Okay. I think, Ms. Lazaro, Mr. Bloodworth, that brings us to conclusion on the motions that are pending in the criminal matter. Is that correct?
Yes.
Okay. Mr. Bloodworth?
Yes, Your Honor, to the extent the motion to compel is concluded.
Well, it's concluded for today.
For today.
Yeah. All right, very good. Let's turn next to the probate case.
Switch spots. Your Honor, perhaps before that, can we discuss scheduling in this matter? I think that was part of today's initial agenda.
Yes, that makes sense. I can appreciate why you wouldn't be comfortable having this matter not have a next scheduling conference, but there's a lot to be worked out on some document discovery issues. Ms. Lazaro, what do you propose?
I think my proposal would be, let's get this order in place with the timelines, and then schedule dates accordingly at that time.
I'm comfortable with that, Mr. Bloodworth, if you are.
Yes, Your Honor. Do we want then to get something on the calendar perhaps mid-December?
Well, I think part of the court's order was that in our proposed order, we come up with deadlines and
for briefing.
For
That'll
briefing. That'll drive the next hearing.
my consideration, and then there will be a sealed hearing, I imagine, to hear from counsel's argument, need to make a ruling.
Okay, Your Honor, then we can perhaps
Yeah.
meet, confer, and propose as part of that.
That would be my
scheduling
preference.
date.
Yeah.
Yes, Your Honor.
That,
Understand.
that works.
Anything else?
If you don't, please let me go around after. No, sir, thank you.
Okay. All right, very good. The probate, now. Mr. Hinton. No, not Mr. Hinton. Right.
Mr. Hinton this time.
Let's begin with the motion for preliminary relief under the Slater statute in case 223-500-019. Can I have counsel for the trustee and the estate make their appearance, please?
Yes, Your Honor. Your Honor. James Tracy and Jake Gorange on behalf of Kouri Richins Benson, who is the personal representative of the estate of Eric Richins and is also the trustee of the Eric Richins Trust.
Welcome to all of you, and then counsel for Kouri Richins in this matter, please.
Yes, Your Honor. Austin Nate and Sky Lazar on behalf of Kouri Richins.
Okay, very good. Mr. Tracy, let me ask you some practical nuts and bolts questions here. You ask for an order enjoining Ms. Richins from dissipating her property and assets, acknowledging that she will have some legitimate expenses that would need to be accounted for.
That's true.
You ask for an order imposing a constructive trust on her assets and requiring execution of a trustee's bond. I have a lot of questions about that order. And then appointment of a receiver to manage Kouri's property and assets, pending a determination of the estate's petition to establish disqualifying homicide. Talk to me first about the order enjoining Kouri from dissipating her property and assets. I'm unclear to what extent your three buckets of relief overlap unnecessarily or duplicate each other unnecessarily. The statute says what it says. You're entitled to some injunctive relief to maintain the status quo. Recognizing there's the abstract possibility that you would be able to prove a disqualifying homicide, we do need to make sure, though, that I do not inadvertently prejudice Ms. Richins' ability to provide for her defense. How do you recommend we do this as a practical matter?
As we put forth in our briefing, Your Honor, we don't object to payment of expenses for her defense on three conditions. One is that they're reasonable. Two, that they're approved by the court and/or a receiver. And three, that they not come from life insurance proceeds or other assets that were Eric's that she wrongfully took. Now, we don't know that we don't have a clear picture of all of her assets.
Pause there for a minute. Money is fungible. Her assets are X amount of dollars. Whether it comes from life insurance or it comes from encumbering real property or it comes from something else, what's the difference?
I think there's a huge difference. Now, again, I'm just looking at the allegations in the information, also the briefing and the detention hearing and the evidence provided.
Sure.
Looking at those things, it appeared that the state had sufficient evidence to establish that Ms. Kouri Richins was in serious financial trouble, and that she had access to millions of dollars of life insurance on Eric Richins' life. Using those facts, it doesn't seem unreasonable to think that most, if not all, most of, or a substantial portion of liquid assets that she had, cash, could have come from life insurance. We think that the court has broad discretion under the statute to preserve the assets of, it says the killer or the killer's estate. I'll just refer to it as alleged
Right.
Okay, so we know what we're talking about, but I don't want to upset the defendants on this matter. But it seems unfair to us. The whole point of the statute is that a person not benefit from the acts covered. And
I
if you
agree. I guess
get
what I'm
life
asking-
insurance and then use it for your defense, it seems that you're doing exactly that. Now,
Well,
how
you're
do we-
doing exactly that if you use other marital funds that did not come from life insurance. Why is life insurance more worthy of protection than other marital funds?
Well, I don't know that it's coming from other marital assets.
You don't know that it's coming
We
from
don't.
life insurance.
We suspect. We don't know. What we know, apparently, there's facts that show that she was upside down in many areas, but we don't know what money she had from her real estate business. I don't know. But this is really gonna be work that we think is appropriate for a receiver.
How would we structure a receiver's involvement so that with respect to approval of her defense costs, Ms. Richins had a clear route to make sure that the receiver was not impeding her ability to fund her defense?
It's very fact intensive, Your Honor. If the receiver hypothetically was put in place and was able to determine that, for example, let's pick a number. Let's say there was $3 million of life insurance, or $2 million, whatever it was, and that all of that was given to her defense counsel for defense. I mean, I think, you know, you would have to know what they anticipate the reasonable cost of defense are. Is she
I'm asking
stashing,
more of a
is she
procedural.
stashing money with
Please don't
defense
talk
counsel?
over me.
Oh, I'm sorry.
I'm asking more of a procedural question. What if she disagrees with the receiver's determination of what's reasonable? What's her relief?
Your Honor, I mean, we come to Your Honor.
You can imagine how much I don't want to be approved
I
of
just
Ms.
don't
Richards'
know.
defense costs.
Yeah. I'm not sure how else we do it.
That's okay. Thank you. All right.
Your Honor, the statute, it contemplates sort of a wide range of options. And by the way, I noted in preparing for this hearing, this section of the statute is just a little over 2 years old. Section 8, which we're dealing with, was put in effective May of 2022. And so, under this statute, and it specifically says before the court determines whether there's been a disqualifying homicide, then the court can enter a temporary restraining order, an injunction, to preserve the property or assets of the alleged killer, or the trustee's bond, or a constructive trust, or any other action, which we think would certainly include a receiver under Rule 66, which is pretty broad as well. Under Rule 66, the court may appoint a receiver in any action in which property is in danger of being lost, removed, damaged, or is insufficient to satisfy a judgment, order, or claim. Now, in this case, Your Honors, we put in our moving papers, and since then, I mean, in the month of September alone, 4 properties were foreclosed on that were either in.
Notices of default, where did foreclosure sales actually occur?
There's been additional notices of default, but in the month of September, 4 properties actually were foreclosed on
Meaning?
that had notices of
Trustee sale,
default and there were
what?
trustee sale.
Okay.
So there is property being lost right now. I don't know what efforts, if any, are being made by Kouri Richins to try to preserve those properties. We don't know what equity, if any, were in those properties. But we do think that this is an appropriate case for a receiver. Exactly what the scope of the receiver's responsibilities are and the authority to make determinations as, for example, reasonable defense costs, I think we're going to have to work through that.
Talking about the constructive trust, typically, right, constructive trust is a equitable remedy imposed after some transfer has occurred to claw it back or provide a notice flag this in, however you want to look at it, to say this is going to be coming back in this direction in the future. How would it work here? In this trustee's bond, the way you've talked about it, it would be money posted by Ms. Richins, but you don't want her to have access to any of her money. You can see why I'm confused.
Yeah, well, it is confusing. Typically on a constructive trust, as you mentioned, Your Honor, it's a situation where someone has money that under the circumstances, using equitable principles, the court will order that that person is holding the money in trust for another person. So in this case, the way it would be applied is when you have a killer, an alleged killer, that person's assets would be determined by the court to have been held and are being held for the benefit of the decedent's estate, whatever they are.
And that order gets recorded against each parcel of property titled in the name of Kouri Richins.
If it's property, perhaps you would record the order. If it's other assets, they're just deemed to be held in trust. And then I guess if there's transfers out, then potentially what you have is a breach of fiduciary duty because they were being held in trust.
How is this better than the claims for fraudulent transfer that you've already done? Or maybe referenced. I looked at the complaint. It wasn't clear to what extent you were actually bringing claims under the Fraudulent Transfer Act versus other causes of action.
Well, there are claims for avoidable transfer, Your Honor, relating, I think, primarily to real property. But as I read the statute, they are giving a court the ability to establish a constructive trust on any property or assets, not just real property, any assets, to preserve those for potential claim by the decedent's estate. I mean, granted, constructive trusts are a little hard to get our arms around because it's kind of it's imposed by order.
Well, the statute doesn't talk in terms of constructive trust, it just talks in terms of trustee's bond, right?
No, it says establish a constructive trust
Oh, I
on
see.
property.
My apologies. Yeah.
And then you can also require an execution of a trustee's bond. Now, I can tell you how trustee's bond typically work. It wouldn't work in this case. If you have a trustee of a trust, let's say you have several $1 million of assets, and the beneficiaries are concerned about the trustee's ability to observe fiduciary duties, etc., they can ask a court to impose a trustee's bond. In a normal case, a trustee could go to a surety company and get a trustee's bond for a fee. But you have to have assets and collateral, and you know how that works. Nobody's going to give Ms. Richins a trustee's bond,
Right.
which means
Cash.
it would have to be cash. And again, we don't know what cash she has. I mean, this is going to be part of the job, we hope, for a receiver to kind of figure out what she had, what she's done with it, what she still has, and then make some recommendations on if there ought to be a bond, if there's a cash bond, if there's, maybe it should be posted with the court, or someone that we can agree on, an escrow company. We don't really know because we don't have a clear picture of what her assets are. What we know is we're aware of 6 or 7 properties. We know that 4 or 5 of those have been lost through foreclosure already. The remaining number of them have notices of default. So whatever real properties she had are either lost or in threat of being lost. And then we have the issue of what happened with all of the insurance money that she collected. All of these would comprise her estate, and the purpose of this statute is to allow the decedent's estate to be able to preserve assets for the decedent's estate. And that's what we're seeking. Exactly what form that'll look like, I think that's what we want to talk to you about and see what's fair. But I think this first step, would be to impose an order that says Kouri Richins shall not dissipate her remaining assets, that ordering that there's a constructive trust imposed as of the date of Eric Richins' death on all assets, and appointing a receiver to manage her remaining assets.
The terms of that receiver appointment would need to be worked out.
Yes.
And, correct me if I'm wrong, I didn't see a proposed appointment order in the briefing order.
Did not.
You've worked out those details.
We have not. We would want to get with opposing counsel and see if we can work out an agreement.
All right, let me talk to counsel.
Thank you, Your Honor. It sounds like you may have some specific questions that you'd like me to address right at the outset on this.
The difficulty here, to say the quiet part out loud, is the legislature drafted a statute with policy in mind. So I can't take the position that this is never enforceable. It says may, so it's not required, but I think it would be an abuse of the court's discretion, or the word may, to take the position that I don't have to do this, so I'm not going to. I'd have to make some findings about why it's inappropriate in this case, and contend with the either explicit or implicit policy decision made by the legislative branch that this is the type of thing that should occur in a case involving a potential disqualifying homicide, which this is. How do you recommend the court navigate those waters?
I think it's a fair question, and frankly, some of the questions that the court has, asked today are some of the questions that we've been asking ourselves. It's just the practical implications, or how you practically actually create a situation where this makes sense, I think is extraordinarily difficult. And just to add to what's already been discussed, I mean, if we're talking about a receiver over all the assets, I think that would necessarily also include, or typically does within a receivership, causes of action that are held or pursued, which would mean beyond
carve those
clarification. Right, so I guess if that's a way to carve that out, and then to the extent that there's a recovery in those cases, does that also automatically become part of the receivership estate? I mean, all this to say, I think that this will expand the scope of litigation substantially. I think that you will be, the court will be substantially more involved in this than perhaps what it would like to be, or what is necessary, or really what is prudent for judicial efficiency purposes.
Right, but come back down to the specifics.
Yeah.
My biggest concern is inadvertently prejudicing Ms. Richins' financial ability to fund her defense. That implicates constitutional concerns that seem paramount. Is there a way to sufficiently fund her defense, but otherwise prevent dissipation, maintain the status quo, protect assets?
We don't believe so, Your Honor.
But why?
I guess perhaps there could be a way to craft that, but again, we're talking about substantial amounts of time, energy, and expense to actually figure out what that's going to look like. And so that in and of itself, going through that process of figuring out how we're going to fund her defense, we're going to deplete resources that would have been allocated to the defense in the first place. Does that make sense?
Sort of. I mean, can we agree that I'm not going to ask you what her assets are, and I don't think it would be appropriate for me to put you on the spot about her right now, but do you know what her assets are?
Generally, I would say yes. Specifically, I would say no.
I have no idea how the legislature expected a judge to make this decision without asking all kinds of questions that I really don't want to ask.
And I think just to add to that, Your Honor, particularly in the case that is as much publicity as this case has. You know, if we get into the injunctive relief, and this is in the briefing, that sort of thing, right? Whether that requires some sort of a finding of substantial likelihood.
Yeah, pause there for a second.
Yeah.
Isn't the easy button on that just to say, as a matter of law, this court rules that the substantial evidence determination is sufficient to satisfy Rule 65A(E)(1, and just stop talking about it?
I mean, certainly the court could do that. I think those are two different standards, and I think we would take the position that for a preliminary injunction, that may well be a higher standard. You know, we obviously haven't gotten into that a great deal in the briefing, but, you know, from our perspective, we think it is a higher standard, and, you know, obviously the substantial evidence, you know, at the pretrial hearing, probable cause still hasn't been shown, and I'm not trying to equate probable cause with what substantial likelihood of success in the marriage looks like. But
Or
perhaps there's
substantial evidence, yeah.
or substantial evidence. So it is convoluted, and it does make it a little bit, you know, tricky, particularly taking into those considerations as well.
Would you acknowledge, though, that in general terms, this kind of case is the kind of case that is targeted by this statutory provision? That is, a situation in which, if a defendant is found guilty beyond a reasonable doubt, or in a civil matter by preponderance of the evidence for a disqualifying homicide, loses any interest in all of those assets?
Yes.
Okay. Talk to me about a receiver. I'm not sure that's better.
You're not sure that a receiver is better?
Right.
And I agree. I think based on the discussion that you had with Mr. Tracy, the practicalities of that is going to be very, very difficult to iron out, and what that looks like. Some of the additional practicalities that I've suggested here, and I think as well too. I mean, they've moved under Rule 66, but there's the Utah Commercial Real Estate Receivership Act, which comes into play when we have real property at issue in receivership, and so that has obviously not been addressed, and I think would be implicated under these circumstances, so would need to be consulted and addressed as well. So, to the again, practically speaking, the receiver makes little sense. I think it makes the process significantly more cumbersome than what it already is, and so don't think that appointment of a receiver would make much sense at all under these circumstances.
Has the estate served Ms. Richins with any written discovery asking her to identify her assets?
In the context of the probate case?
Correct.
I do not believe so.
In the context of any other case?
I don't think so.
Okay.
And I could be wrong. There's several cases, obviously, and lots of written discovery, but I do not believe so.
All right. Okay, let me ask Mr. Tracy some more questions.
Thank you, Your Honor.
Mr. Tracy, what's the irreparable harm here? There are other tools available to the estate to identify assets in the flow of money, to trace the flow of money, to provide notice to potential bona fide purchasers or other transferees, and to claw back assets. Money in many ways is fungible. Why is there irreparable harm here if I don't put any injunction in place, but allow you to start figuring out through the discovery process the answers to the questions you don't currently know the answer to?
Well, first of all, Your Honor, typically in civil litigation, we're not allowed to inquire as to a defendant's assets without a judgment. In this case, because
This is a little different.
I know it is, but I guarantee in some of the, like for example, the civil fraud case, they're not going to answer questions about what her current assets are. In fact, they moved to stay the case, which you'll hear here in a minute from my partner, Mr. Gorringe.
Right.
Let's talk for a second about, and by the way, in the estate case, we did demand an inventory. As part of the inventory, we asked for disclosure, but we haven't got a disclosure. But it's something we can follow up with motions in the estate case. But I do want to be clear, and I think you asked a question about Rule 65. As we put in our briefing, it's not clear that Rule 65 applies to paragraph 8A, 75-803, sub 8, paragraph A. It certainly does on paragraph B, but that only applies if you're seeking an injunction without notice or an opportunity to be heard. We don't concede that Rule 65 applies, and in fact, in preparing for this hearing, I'm more convinced that it doesn't, and we could submit briefing on that. I think the legislative history will show that Rule 65 was inserted only if you want a injunction without notice or an opportunity of a hearing. Under subsection 8A, no mention of Rule 65 is made. So I don't think that we're subject to the substantial likelihood of prevailing on the merits. But we addressed it in our motion in this way: even if we were subject to it, we meet the requirement. And to that, I would, in addition to your rulings in the criminal case, we had 45 facts set forth, cited by evidence, and they didn't dispute it. They relied on her Fifth Amendment right, which she has the right to do, but in a civil matter, it comes along with an adverse inference.
Sometimes the law, and that's a little more complicated than you let
Well,
on.
she didn't rebut any of the facts. I don't think we really have a problem meeting the standard under Rule 65, but I don't think it applies technically.
This is why I'm asking you about irreparable harm. Why is injunctive relief necessary here? What about the status quo can't be either compensated in the future in money damages, preserved through other means, better characterized? I mean, just because I don't grant the motion today doesn't mean I can't grant the relief.
Well, first of all, I don't concede that you can't get an injunction only when your damages can be compensated through money damages, because there are circumstances where you just will practically, you'll never recover the money. And I will mention, what if there's nothing in 75-803 that carves out an exception for attorney's fees, by the way. And in every case where you have a disqualifying homicide, you're probably going to have a murder trial. I mean, more likely than not. So I don't know that the legislature was concerned about how do we carve out defense costs. When we prepared our motion,
The Constitution might be concerned. I said the Constitution might be concerned.
which is why in our motion, we specifically stated we're not seeking to prohibit her from having reasonable defense costs. I just make a note for the record, there's nothing in the statute that carves that out. Again, you have a variety of things in the quiver here that you can use to address this. Just imposing a constructive trust seems contemplated.
Why
and
not?
I can't see why not to do it.
Why not freeze? Enter an order freezing her assets in their current state of title, meaning can't hypothecate any of the assets out of current states of title. If they're titled in the name of Kouri Richins, they stay that way until further order of the court. If they're titled in the name of
Kouri Richins Realty.
think I can reach that entity since it's a single member LLC.
We think so.
She'd be the human being that would be acting on its behalf. So if they're titled in the name of KAR, they stay that way. If there are funds in a bank account, they stay in the bank account. And then press pause. And let you all get me better information about why you think this will or won't work. You're asking me to shoot in the dark here.
Because we are in the dark.
I know, but if you'd serve some discovery, we'd all be better off. And now, there may be reasons that hasn't happened yet, but I'm just saying there are tools available. What do we do about the fact that her properties, or properties titled name of KRR, have notices of default?
Well, it's going to take an analysis of whether there's enough equity in there to bother trying to rescue them. But I do-
Presumably, Ms. Richins has an equal financial incentive to do that, right?
Depending on the amount of equity in it.
Sure.
If it's only $20,000 of equity, maybe not. With regard to your suggestion, Your Honor, we would welcome and certainly we would welcome and take from the court a freeze of recurrent assets. I think in addition to that, I would ask the court under 75-2803 order that the constructive trust on any property or assets of Kouri Richins was effective from the time of Eric Richins' death. What that means exactly, I don't know. But
Tough sell.
I'm just telling you, I mean, it should be a constructive trust. What that means as far as the consequences of that, I don't know until we know what she did with the assets.
I'm not opposed to that concept in terms of at least casting a net that goes back in time. How would I structure that constructive trust to have an exception for assets that have been used or would reasonably be used to defend herself?
Here's what I think one way this might work. The court's order could say freezing all of the assets, as you just mentioned, as of today and going forward. Now, in addition, the court, pursuant to this section, orders that a constructive trust, or that all property or assets of Kouri Richins is subject to a constructive trust in favor of Eric Richins' estate from the time of Eric Richins' death, period. I mean, it's up to us to decide what we do with that. And here's what I would say. If then, after we find out more about what she's done with her assets, if she made what we think is an unreasonably large transfer, far beyond maybe what was needed for reasonable defense costs, then we would argue that that was a breach of our fiduciary duty.
Nice.
They would argue it's not, and they would tell us why it's not. I don't know how that would turn out. But I think under the statute, it's fair to say, if, in fact, she's guilty, we don't know if she'll be found guilty or not. But if someone's found guilty of a murder, it's certainly not unreasonable that any of their assets from the time of the death of the victim forward were held in constructive trust for his or her estate. That seems pretty reasonable.
And so the parties would have their respective arguments about whether expenditures since Eric's death to now were within or outside a proper exercise of Ms. Richins' fiduciary duty.
Yes,
All right.
that's what I think.
Okay. Thank you. Let me ask Mr. Nate some more questions. So Mr. Nate, let's focus on those two things.
Yeah.
In order, freezing the assets as they stand today, no hypothecation of anything, no transfers with for or without value, and establishment of constructive trust with the parties reserving their arguments about whether any distributions, use, transfers of assets to date were equitable, appropriate, within a fiduciary duty outside of it. You wouldn't be waiving any arguments in the future to say, Judge, this is too restrictive, you gotta loosen it up so that she can defend herself. It would maintain the status quo. It would honor at least some of the intent of the statute. It would protect the estate of Eric Richins. Not as specific as I can be, given what I know right now. What's your response to that?
I think first and foremost, obviously, our position is that no relief should be granted and that the court has, discretion under the statute and should deny the motion. To the extent the court is inclined to do anything with respect to this motion, I think the relief that you just laid out is would probably work and would probably be fine.
At least for now.
For now, for present purposes, yes.
Okay. All right. I appreciate that. Anything else on this?
No, Your Honor.
Mr. Tracy, you're entitled to the last word. Is there anything else?
Just, Your Honor, I think that in an order that you might issue, you should make clear that we're allowed to proceed with discovery on our assets. But again, I know you've got a motion to stay that you're going to hear,
Great.
and that can be part of the decision on that as well, I suppose.
We'll get there.
Thank you.
Okay. All right. All right, the issue before the court is a motion brought by the estate of Kouri Richins for preliminary relief under Utah Code 75-2-803, subsection 8A. The estate requests an order enjoining Kouri from dissipating her property and assets while also acknowledging that Kouri Richins will have legitimate expenses, such as the cost of her legal defense in the criminal matter. The estate also asked for an order imposing a constructive trust on Kouri's assets and requiring execution of a trustee's bond. And the estate asked for appointment of a receiver to manage Kouri's property and assets pending a determination of the estate's petition to establish a disqualifying homicide. The motion is granted in part and denied in part as follows. First, to the extent that the four factors under Rule 65A(e) must be met before the court may impose injunctive relief under 75-2-803, subsection 8A, the court finds they are met in this case for the following reasons. With respect to factor E1, the court finds that factor is satisfied as a matter of law by the court's determination that there is substantial evidence supporting the aggravated murder charge in this case. Regarding factor E2, the court acknowledges that the difficulty of recreating, chasing, and reversing any flow of funds or dissipation of assets that might occur during the pretrial period in the criminal matter poses an irreparable challenge to the estate in terms of maintaining Kouri Richins' assets for distribution to other parties in the event she is found to have committed a disqualifying homicide. Court determines under factor E3 that the threatened injury to the estate outweighs the damage to Kouri Richins that a carefully tailored injunction would pose. And under factor E4, an injunction is not adverse to the public interest and in fact is consistent with the public policy put in place by the legislative branch when it passed section 75-2-803, subsection 8A. Having determined that some form of injunctive relief is appropriate, the court is nonetheless concerned that an overbroad injunction will be constitutionally infirm because it will unduly burden Ms. Richins' ability to fund her criminal defense. And to avoid that prejudice to Ms. Richins, the court determines that a limited injunction in the following form is important and appropriate. First, the court is hereby issuing a preliminary injunction that hereby enjoins Kouri Darden Richins from transferring changing the title of or otherwise hypothecating any asset that she currently holds or controls, or that her realty company, KRR, currently holds or controls. Second, under subsection 8A, 3, the court hereby establishes a constructive trust on all property and assets of Kouri Richins and KRR Realty. The constructive trust is effective from the date of Eric Richins' death. The court will consider in the future as necessary arguments that transfers or disbursements of Ms. Richins' assets to date or in the future are reasonable and necessary to fund her criminal defense. And the court recognizes that exceptions to its order enjoining any transfers or changes in her current asset titling or holding may be necessary for that purpose, and exceptions to the constructive trust may be necessary for that purpose as well. The court is not imposing the requirement of a trustee's bond. It is not appointing a receiver at this time. The court denies those requests without prejudice. Mr. Tracy, I need you to take what I said and make it look good on paper. I need you to run it by Mr. Nate for his objection or approval.
We will do that.
Okay. Mr. Nate, any questions?
No, Your Honor.
Mr. Tracy, any questions?
No, Your Honor.
All right. That brings us to related motions to stay, the probate case and the wrongful death case, pending the outcome of the criminal case. That briefing has taken some twists and turns. Mr. Tracy, Mr. Gorringe, what is, pardon me, I'm doing this in the wrong order. Mr. Nate, Ms. Lazara, what is the scope of the stay you're currently requesting in those two civil cases?
So, and again, just to be clear, with all the cases that are going on, we're talking about the probate case and the trust case, correct? Did I catch you correctly?
I may be using different vernacular than
Okay.
you use. I apologize. So, what I have been calling the wrongful death case is 262.
Okay,
And then the probate case, I think, is 019, the estate case, right?
correct.
Okay.
So, with respect to the wrongful death case, and do you want me to come up to the?
Wherever you're going.
Yeah, I'll go ahead and come up there. So, with respect to the wrongful death case, there are some preliminary discussions with what a stay might look like. The plaintiffs in that case, or the plaintiff in that case, the estate, has agreed that some form of a stay is, that they don't object to it. But we haven't really been able to reach an agreement on that, and from our perspective, we think the overlap with the wrongful death case and the criminal case are so substantial that we maintain a position that a complete stay on that case is necessary and what we're asking for.
So pause there for a
Yes.
second.
Okay.
I don't know if this is accurate, but I think it is. Imagine, though, for the purposes of the hypothetical, that the wrongful death case, ending 262, includes some will transfer causes of action. Why shouldn't they be able to go out and try and claw back some assets, get them back into Kouri's estate? They would need, maybe they wouldn't need testimony or admissions from Kouri to do it, but if they asked for it, you would have your right to object based upon Fifth Amendment grounds or others. Well, why would I state that?
So, I think, to make sure I'm understanding the question right, is the idea here that perhaps you stay some claims and allow some claims to move forward, correct?
Right. There's a lot of claims. I mean, this gets messy
Right.
fast.
Correct. And I think just from an overall or an overarching purpose, as we've stated in our pleadings, piecemeal litigation associated with pursuing some claims, not pursuing other claims, I think undermines judicial efficiency. I think it's unclear at this point, do I think that there's some potential that voidable transfer claims could be implicated somehow in the criminal trial? I think it's possible. I don't have specifics on that right now, but you add that to the already very substantial allegations that are overlapping between the two cases, and I mean, we think that that certainly would lend itself to staying the case in its entirety, and again, to allow the whole case to move forward at once or to stay the whole case in its entirety. And I think that, you know, supports judicial efficiency. It also avoids unnecessary duplication of work, you know, as set forth in some of the cases that we cited in our briefings.
What about the 019 case, the in re estate of Eric Richins? Why would we stay that?
So, and again, just the verbiage that we've used on that is either the estate case or the probate case to make sure we're talking about the same one.
Yeah.
So, you know, we filed a motion to stay in that case. You'll note from our briefing, though, on the, perhaps, I think it's in the reply in the 262 case, I don't think, and you know, we take the position in the papers, I'm not sure that Kouri has the ability to stay collectively the administration of an estate, right? I mean, and that's why we point that out. And so our motion to stay in the context of that case was narrowly tailored to, one, you know, prevent, or, you know, staying, you know, any action with respect to the petition to determine a disqualifying homicide, which for obvious reasons, right? And then any other aspects of that case that would, you know, require the active performance of Kouri to, or you know, anything that would require active performance in some aspect of the administration. So I don't think that case should be stated in its entirety. We haven't taken that position. And you know, hopefully we've made that clear through our briefing, that it should be narrowly tailored to, you know, the aspects of the estate administration that implicate Kouri, including the petition for disqualifying homicide.
Do you acknowledge that proportional discovery in the estate case might include identification of Kouri's assets, where they are, where they went?
Particularly in light of the court's ruling today, yes.
Okay. All right, that's helpful. I appreciate that. Thank you.
Perfect. And then I guess I will just add as well, we have the original case that was filed that ends in, I think, 7-6. That, I mean, that one.
There's no briefing in front of me on that case right now, is there?
So there's still a motion to stay that's pending in that one as well.
I apologize. Okay.
So I'm happy to discuss today. If you would prefer to defer, that's, you know, fine.
Is that Kouri's case against Katie and her capacity as trustee?
That's correct.
So whatever I do with it would seem that whatever the court does with the elements of the estate case, other than the petition to determine disqualifying homicide, it should also do with that case. That is, if I allow the remaining elements of the estate case to go forward, I should allow Kouri's claim to go forward as well.
That's correct, and we've gone, you know, and there have been discussions with opposing counsel. We sent an email, I think when it was originally set for hearing back in August, trying to work things out. Unfortunately, we haven't been able to reach a stipulation on what that stay would look like. From our perspective, we think it makes sense to reach a determination as to home ownership and personal property ownership, right? That those shouldn't be stayed, but that, you know, the remaining claims, including the counterclaim, should be stayed, because those do not carry I guess carrying cost is kind of what we've been thinking of, right? It doesn't make much sense for the trust to continue to carry those assets if there's not going to be any residing there or anything like that. So we've taken the position that the state should not apply to those, that Kouri should be able to pursue those claims, but that other claims, the remaining claims in that case, should be stayed.
I feel like it's going to have unintended consequences that I can't quite identify at the moment. Okay, I understand your position.
Yeah.
What is the case number in that case?
It ends in 7-6, I believe.
Okay.
Your Honor, it's 220500076.
Thank you. Okay, I appreciate
Yeah,
it.
thank you, Your Honor.
Mr. Kouri.
Yeah, and just another point of clarification. So there's also the case ending in 230, which is Kouri's case against Katie in her capacity as personal representative. Now that case arose from the probate case, right? So the genesis of that is, in the probate case, Kouri files a claim against the estate. We disallowed it. Then under the probate code, she had 60 days in which to file a petition for allowance or a separate action. She elected to file a separate action. So now we have what we've called the estate case pending over here, which ends in 230. And I believe that Kouri's motion to stay in the probate case touches on that as well.
Give me that case number one more.
Sure. 230500230.
230500230.
Correct.
All right. Mr. Orange, I, at the moment, acknowledging that I may need to revisit this issue depending upon how much frustration and mischief arises in discovery, am inclined to stay any proceedings related to the petition to determine disqualifying homicide in case ending 019, and to stay case ending 262, the wrongful death action in its entirety, but to otherwise not stay the remaining civil actions or the remaining elements of 019. My reasoning being, there seems to be an immediate need to address what assets are held by whom, what their status is, and whether some changes to that status need to be made. And I think that can be accomplished under the situation I just described. Do you see it differently?
Only in one small respect. Let me address that. That's on case 262, which is the case in which Katie's, the wrongful death case.
Right.
So the only issue I would take is with respect to Katie's voidable transfer claims, which you mentioned. Those voidable transfer claims are narrow. They deal with a transfer that occurred just earlier this year with respect to a piece of real property that Kouri Richins Realty transferred to Lisa Darden. There are other defendants in connection with those voidable transfer, and there's also a civil conspiracy claim. And so we can't contemplate how that would come up relative to Kouri's criminal prosecution, simply because it's a transfer that occurred so long after any, I think, what's salient for purposes of prosecution. I don't know whether the prosecutors are going to look into that, but it doesn't seem relevant to us. And to the court's point, one of our concerns is trying to get that asset back into the estate. Otherwise, I think we're fine staying the remainder of 262, other than we do want the ability to conduct third-party discovery. That's just the issue.
But I think you could do that. This is why I was pushing Mr. Nate a little bit on the proportional discovery in the 019 in the matter of the estate of Eric Richins' case. It seems like you could do that there.
And we don't have a problem. As long as we can go get records from third parties, we're good.
It seems to me that proportional discovery in that 019 matter, conducted by the trustee on behalf of the trusts or the estate's beneficiaries, either the trustee or the PR, right? In the 019 case, the nominal plaintiff is Katie in her capacity as what?
Well, personal representative.
Okay. So in her capacity as PR, I think proportional discovery would be, I need to go figure out what's out there and where it is, and that would include third-party discovery.
And as long as the court's order is tailored to reflect that, we have no problem with that.
Okay. Have a seat. I'll make sure you get the last word.
All right.
Mr. Nate, did I provoke anything else, sir?
Just one point, Your Honor. I did want to highlight the fact that Johnston Bird, who represents Lisa Darden and Ronald Darden, is here today. In this case, right here, to the extent he has anything to say, obviously wanted to make sure that the court was aware because they are also parties to the 262 case.
That's right.
In Lisa, so I wanted to make sure he had the opportunity to say something.
Thank you. Mr. Bird, anything to add, sir?
Yes, Your Honor. Just briefly, regarding avoidable transfer claims, and that's where our interest lies in this case. This isn't our motion, but we do have an interest in the case being stayed. A lot of it goes to the judicial efficiency of a stay, in that the premise of those transfers being voidable are related to the criminal claims against Kouri and KRR. If KRR and Kouri is, they're found not to have committed any kind of wrongful actions here, then the premise of those transfers having been voidable is disproven and baseless.
True, but under the current state of facts, right now, there's a claim, isn't there, under the definitions of the fraudulent transfer, avoidable transfer act?
Yes, there is a claim that's sufficient.
Now, that claim will cease to exist, right, if she is not proven guilty.
That's correct, Your Honor.
But at the moment, the claim exists.
At the moment, the claim exists, but it's a matter of pursuing that claim and conducting discovery into that claim, and the eventual possibility of having all of that been for naught if there's later found to be no wrongdoing. So a stay, it's a judicial economy thing, it's also preservation of assets within the trust. A stay would allow those claims to be adjudicated after the criminal liability has been determined, and then we'll know one way or the other whether a basis for those voidable transfer claims exists.
Well, what would prevent a BFP from receiving that piece of property in the intervening period? I think the answer is nothing, right?
Yes, Your Honor.
Then the claim is worthless, you can't get it back.
Correct.
Okay. All right, I appreciate your position. Anything else?
No.
Okay, thank you. Okay, Mr. Gorge, anything else?
Just one quick point, and this is just more of a clarification. I think this is the direction you were heading, but I just want to make sure. So in case 262, Katie's asserted claims both in her capacity as personal representative and as trustee. So if Katie is, 262 is state, and Katie's doing discovery through the probate case as the nominal plaintiff in her capacity as PR.
Right.
Is she going to be able, we just want to make sure she'll be able to conduct necessary third-party discovery in connection with claims that she's asserted as trustee in case 262.
Aren't the duties the same? I mean, doesn't a personal representative have a duty to protect the assets and distribute them lawfully for the benefit of all beneficiaries of the estate? All heirs, not beneficiaries, but heirs.
Certain heirs of the
I
estate,
mean,
yes.
doesn't a PR have a fiduciary duty to all the heirs of the estate?
Yes,
Doesn't
absolutely.
a trustee have a fiduciary duty to all the beneficiaries of the trust?
Certainly.
Okay.
I just didn't want to run into an objection where we do discovery that is specifically in connection with a claim that Katie only has in case 262 in her capacity as trustee, and we get an objection that
Sure.
in 19 it's not relevant to the estate.
Tell you what, if I'm wrong about this, I will happily accept an "I told you so" judge when it comes up at a discovery dispute, but I think I've got this right. Okay.
All right, nothing else.
Okay. All right. Let me try and make a ruling that embodies the court's intent, and I'll ask you if you need any clarification. Before the court are 3 motions to stay. These civil matters, or at least parts of them, pending resolution of the criminal case. Those are filed in cases ending 262, 019, and 076. Those motions are granted in part and denied in part as follows. Case ending 262 is stayed in full with one exception. Plaintiff's claim for voidable transfer with respect to the real property transfer to Lisa Darden is not stayed. Case 019 is stayed only with respect to the petition to determine disqualifying homicide. All other elements in case 019 are not stayed. Case 076 is not stayed. Case ending 230 is not stayed. Mr. Orange, I think I got that right. Does that sound correct?
Sounds correct.
Okay.
I have two questions.
Please.
Is there and we didn't talk about this, and I should have, is there an end date on the states? I know that, I think.
Not at the moment. I mean, by not imposing an end date, the court is not in any way limiting a party from filing a good faith motion for partial or complete relief from the stay.
Okay. And then I assume that if circumstances weren't, I don't have anything in mind, but if under appropriate circumstances, there was cause to move to lift the stay, either party could do that.
I think that's what I just said.
Okay.
Okay. Mr. Any clarification needed?
No, Your Honor.
Okay.
Yeah. So, Your Honor, I think there's one thing that's been overlooked, and Mr. Nate can correct me if I'm wrong. In case ending in 076, which you indicated was not stayed, there were at least a few of those claims, counterclaims, that I believe the parties, I think, probably agreed that should be stayed
Counterclaims brought
by
by.
Katie as trustee, including that a power of attorney was fraudulently signed, that a second mortgage was obtained in violation of her fiduciary duties, all of which came up in your detention hearing. So I think we had agreed that those would be stayed, so
Okay.
we're happy, we could have run away and said, ha-ha, but I think it's better, since we're here, let's just clear it up so we're all on the same page. I don't think either side,
The Katie's counterclaims in her capacity as.
trustee,
Okay.
because she is the owner of the home that's subject to the second mortgage that we, of $250,000, that we say was obtained with a fraudulent power of attorney.
I understand. Mr. Gornick, can you please amend your notes regarding the order that I'm going to ask you to draft to include a partial stay in case ending 076 that stays Katie's counterclaims in her capacity as trustee? Thank you, Mr. Trustee.
Well, those would only apply to the fourth and fifth claim, I believe, Your Honor.
What are the other counterclaims?
They related to the operating agreement and buy-sell proceeds, which you,
I think I resolved those.
well, we think so, but I think in our negotiations, I think the other side thinks that maybe there's something there. We'll work that out. They're either resolved or they're not stayed, but I don't think.
I'm going to stay all of Katie's counterclaims for the moment. If through your discussions you think this is overbroad, I will of course consider a motion to adjust the scope of the stay. But we need to have some clarity when you all leave the room today.
Right. The problem is the first three claims relate to the buy-sell proceeds, which we thought was resolved.
The first three claims or the first three
First three
counterclaims?
counterclaims have basically parallel claims. So if you're going to stay Katie's counterclaims there, they've got to be stayed in the claims. They're
Are
the
they just
same claims.
declaratory judgment actions going like this?
Yes. We're entitled to buy proceeds. They say they're entitled to the buy sell proceeds.
Didn't I already rule
We-
on that? And the
that's-
buy-sell
think
proceeds
so.
were in fact disposed of?
So, in this, Your Honor, perhaps we should have asked for clarification at that hearing. Because in the way that the ruling was issued, it was that the assignment to the trust was effective. So the trust was entitled to receive those proceeds. They were, they asked for quite a bit additional relief in respect to those claims, and the court denied the remainder of the motion for summary judgment. So we think there's still issues to be addressed. in that
Why
respect.
aren't those proceeds now in the trust estate to be distributed according to the terms of the trust?
Well, I guess we were taking the court's ruling, because I think they had, and you guys correct me if I'm wrong, had specifically requested in their motion to be able to dispose or to, use the proceeds as set forth in the trust. And since that was not included in that portion of the ruling that was
I
granted.
recall taking the position that the trustee of the trust would just exercise his or her fiduciary duty to do with the proceeds what the trust requires. I didn't need to make the order.
Understood, and if that's the order, then, then we understand.
That was our understanding, Your Honor. You didn't need to go there, and so you didn't.
Right. Okay. It sounds like claims 1, 2, 3 from Kouri in case ending 076 and counterclaims 1, 2, 3 from Katie in case 076 are now moot. But why don't you talk to each other and let me know if you agree?
Perfect. And then I do, based off of Mr. Tracy's, identification of those additional claims, we had previously discussed, and I think agreed, and again, they can correct me if I'm wrong, the final 2 claims in case ending in 076 relate to removal of Katie as trustee as well as breach of fiduciary duty. We had agreed to stay those claims as well. I didn't see a need to pursue those at this time. I don't know if we want to include that now, if that's not part of it.
I am now coming to the realization that what you previously agreed to was stay all of case 076.
Essentially,
Well,
except for,
not the home. The home ownership, personal property ownership. That's an issue.
Forgive me, we've taken a lot of twists and turns in this case. Is the home ownership still a live issue?
It is.
It is, Your Honor.
Okay.
Yeah, in some respects it is, yeah.
And which claim in 076 is that?
Your Honor, that would implicate Kouri's second, third, fourth claims for relief.
But the home was titled solely in Eric's name, correct? Kouri's claim is to an equitable interest, correct?
Correct. We also have a pending motion for summary judgment on her third claim for relief that, with regard to tenants in common, that you stayed
Okay.
last time we were here, pending your resolution of the motions to stay. But that's been fully briefed and ready for a hearing.
I don't think I'm going to be able to, based upon your oral representations today, navigate how best to determine the motion to stay in 076. So why don't we back up a minute? I think my rulings regarding the motion to stay in 019 and 262 is appropriate, well-founded, it stands. The court is continuing any discussion or consideration of the motion to stay pending in case 076 to allow you all to meet, confer further, and then perhaps submit some final serve replies and tell me how you want me to rule given where we are right now.
Your Honor, I suspect, given your direction that you've given us today, I would anticipate we could work out a stipulated stay.
I am
We
hopeful that
see
you
where
do.
you're going, so.
Okay. Mr. Gorge.
Case 230, you had previously said that was not stayed. Are you continuing that as well, or just for clarity?
That's the claim brought by Kouri against Katie as in her capacity as PR, right? Include that in your discussions. I remain a little fuzzy how it relates to the active claims in 076.
And we will do that, Your Honor. Just for your clarification, I think it's safe to say that the Kouri Richins versus Katie Richins Benson a case ending in 230 is almost identical, if not completely identical, to their claims in the 7-6 case.
Sounds like your discussions will be.
They just brought it
Okay.
against the estate instead of the trust.
All right. We'll see what comes out of this. Either file a stipulation or a request to submit so I know to look at. All right. Mr. Gorge, with respect to the court's ruling about the pending motion to stay in cases ending 262 and 019, please prepare a proposed form of order and serve it on Kouri's counsel for their approval or objection. All right. Okay. Mr. Tracy, Mr. Gorge, anything further today?
No, Your Honor.
Mr. Dean?
No, Your Honor.
All right. Ms. Richins, I wish you the very best. We will determine your next court date in the criminal matter after counsel have had some time to discuss a briefing schedule regarding the privilege issue on those two documents. I wish you all the very best. Please listen to the deputies as you file out to keep things orderly. Have a great weekend. Court's in recess. Thank you.